Good morning, everyone. Today is Tuesday, September 14th, one day before the corporate tax filing deadline if you're on extension. So you will note the absence of my counterpart, Marina Parkin. But I am pleasantly joined today by Mindi Wells, a colleague of mine from law school. Well, she was done with law school before I was, but we were there around the same time. Mindi has an employment law practice and is so gracious to volunteer topics and provide us with information. So thank you so much for joining us. Mindi was one of the very first people who helped me get to Florida and escape from Ohio. Now everyone else is catching on, but I was kind of first in line there. So today we wanted to talk to you about employee handbooks. That is probably the one thing when we set up businesses that people aren't super keen to hearing about, particularly in the beginning. A lot of new businesses start out with just the owner doing all the work, you know, hands on and head down doing the work. And then what happens is they hire, and then all of a sudden there's 10 people and there's no employee handbook. So the new HR person who knows a little bit about QuickBooks and can download a handbook off of Google creates the handbook, and I can't wait to hear what kind of disasters ensue after that.
And I've seen plenty of disasters.
So I understand you've got the recipe and I'm all ears.
Awesome. Well, thank you so much, Joanne, for letting me join you and your team. I love watching your webinars. They're always entertaining and interesting. So I hope I can uphold that standard that you guys have set. Employee handbooks are a favorite topic of mine. Particularly because I find that small businesses oftentimes, as you said, start off with maybe just one or two of them, usually friends or family members, and then before long they're growing, and they're like, oh heck, I can't get this cat in the bag, and these, you know, they're all running amok, and everyone's doing 5 different things, and I really want to talk to people about stopping doing something, but I don't have any policies, or I don't know how to stop this. And so it's never too soon to have an employee handbook. I don't even care if you don't have any employees yet. If you think you're going to hire one next month, I'd get your employee handbook in shape today. So for anybody who's like, I don't have a handbook, this is a great topic for you. Mm-hmm. For people who are like, I have a handbook, this is a great session for you. And for people who are like, I hate the handbook I have, but I'm stuck with it, that's okay too. Like, so this is a handbook conversation for every type of business owner. And even those folks who get saddled with the HR hat with no HR background, I hope that you'll find that by the end of our conversation today, you have just a few tips or takeaways that you can put into practice in looking at the policies you already have. It can be a really daunting task to write an employee handbook, and people oftentimes put it off because the day-to-day fires they're trying to deal with take precedent, and the handbook is just like not something anyone gets out of bed in the morning going, hey, I really want to work on the employee handbook today. So,
but you,
but me. So what I want to do is talk to you a little bit about why it's worth having a handbook, like how we use them or how the absence of them can hurt you as a business. And then I want to talk about some of the most common mistakes that I see businesses or business owners in their thinking as they approach their employee handbook. I want to talk about some things for you, some questions for you to think about asking yourself if you do have an existing handbook, like how to kind of look through your handbook and ask yourself some core questions. And then I'm going to touch on some policies. If you haven't looked at your handbook in the last 2 years, some things you should really think about. And certainly if you haven't relooked at your policies in light of COVID, I'm going to give you some COVID issues that have surfaced that could be addressed with a handbook too. So we've got a really aggressive kind of list of topics to cover this morning. If you have questions, you can drop them in there. Joanne's going to try to insert them as fast as I'm talking. So I hope that I'll be able to hit the questions that you have. I know this is a chock full topic, so we'll cover as much territory as we can. And if we need to do handbooks part 2, we'll come back and do it another time too. So. And occasionally I have a few notes for myself. So if you see me look over to the side, I'm looking at a couple of my notes because I want to make sure and hit some key elements as I talk with you today. So let's just jump in initially to talk about, do I really need a handbook? So the answer to literally every business owner I talk with who says, do I need a handbook? It's a heck yes. Like, you need a handbook. If you're going to have workers, you need a handbook. Well, why do I need a handbook? Well, for several reasons. One, it really is the playbook for your company. It's the rule book for success for those employees. It tells them what we expect them to do, how we expect them to do it, how to bring up problems, and what kind of benefits we're going to offer, and just all of the rules of the game. It's really their owner's manual for becoming a member of your team. So why wouldn't we give them that? it's our hope that they're all successful and that they meet our standards, but they can't read your mind. And so the employee handbook is a way for you to get those standards written down, communicated consistently to all the staff. And that's really important from a legal standpoint, is consistent application of the policies so that you don't get accused of favoritism or worse yet, discrimination somewhere along the way because different policies or practices have applied to different people. So having handbooks set your employees up for success. It sets your company up to have some minimum standards of consistency that if you are accused of something, we can say, no, this is our policy. We do this all day, every day. But I think really practically, one of the most important reasons to have the employee handbook is that it gives your supervisors and managers some tools to be successful. So when they want to address something with their employee, it's just not them pulling this new idea out of their back pocket or worse yet saying, well, the owner told me I have to tell you this, or the owner said, or so-and-so said you have to do this. We can say, hey, look, it's not personal, but on page 12 of our employee handbook, we specifically state that you're not allowed to wear t-shirts that say F you on it to work. Like, we have a dress code of a certain standard of what can be worn or can't be worn specifically. So it's not personal. This applies to everyone. Just here's another copy of page 12 and let's come back tomorrow and, reset. And so it helps take away a lot of the pressure for your managers if you can give them this guidebook essentially that they can refer to, so that when someone needs an additional amount of coaching or a friendly reminder, it's not a personal issue of the manager. It is here's what the company has told us all. We all have to abide by page 12. So I just want to give you a friendly reminder and help you be successful here. So it's a really super important tool for the employees, but it's a really, really important tool for your managers and supervisors. So
especially as you grow and you may have more than one supervisor or more than one layer, then they're consistently applying those rules too. So it's not like, right. Blue's just really not her favorite color, so that's why she was mad about my blue FU shirt.
That's right.
Or put it under your dress. You can still wear it, just wear it underneath.
You looked at me cross-eyed. So what the other thing we find too is, as people come and go, managers come and go, people learn from people before them. And if you don't have a certain set of rules and guidelines in this playbook for success, then rumor and hand-me-downs and that's how we've always done it becomes the rules of your workplace. And that's probably not what you intended. So in the absence of clear information, employees make up their own. But I also take this side opportunity to say, if you have an employee handbook and you are trying to address an issue with a staff member and they say, well, that's not in the employee handbook, I jokingly say to my clients who are like, Mindi, do we have a policy on fill in the blank, some crazy obscure topic? I'm like, no, but you always as an employer have the right to set rules and expectation and boundaries and to give instruction that people have to follow. Our handbook also says, don't pick your nose, but we know we're not going to tolerate that at work. So the handbook can't cover everything. It's not a play-by-play detail of how to act like a civilized adult at work, but what it does communicate to them is these are expected sets of behaviors in our workplace, and in exchange, these are the benefits and the culture and the work environment that we're going to provide for you. So it's not going to cover everything. It's not going to cover play-by-play details, but really the core rules and expectations of your staff. Then it gets passed down manager to manager, and it's consistent across time. And however many, if you have multiple locations, a handbook's even more important to have consistency of those policies. My last reason for saying why you really need a handbook is, I hope you never need it for litigation purposes, but as an attorney, an employee handbook is just like, oh, thank goodness. So when and if one of your employees, God forbid, decides to file a complaint against you with the EEOC, go get a plaintiff's attorney, file with the Civil Rights Commission, take some kind of formal action against you as an employer for something that you've done to them, allegedly done to them at work, generally that investigating agency or the plaintiff's attorney will send us a letter. And I have common language that I see in these letters. We want job descriptions for all the positions that the plaintiff has held. We want workplace policies relevant to the adverse action in effect at the time that you did XYZ to my client. Mm-hmm. We want the table of contents and an index of any employee handbook that's currently in applicable to the employee at the time of this incident. We want the plaintiff's performance evaluations, and we want the plaintiff's formal discipline record, including documents concerning the termination of the employment relationship at issue in this complaint. So that's very common, a first letter. So I always am interested in my clients having an employee handbook, one, and then two, if they have it, consistently following it. So if you're not going to follow it, don't bother, because the worst thing we can do is have an employee handbook that we don't follow, so that when we are accused of discrimination and they say your policy on page 25 says you're going to do this and this is what you did to my client, and I'm like, oh hell, why'd you have a policy if you weren't going to follow it? Because now the plaintiff's attorney is just going to point out how far more discriminatory you were with the client or with the employee, his or her client, because you had a policy that said we commit to doing things this way, and oh, guess what, we didn't do it for that one person. So have a handbook, but follow it. If you're not going to follow it, or if you have really rogue leadership, or commonly I hear people say, well, our owner won't follow that, or everybody else will follow it, but the CEO doesn't. And I'm like, well, everybody needs to. The handbook applies to everybody. And so the importance of having it is going to be overridden if you apply it inconsistently. It kind of backfires on you. So it's important to have one.
Also means if you're going to follow it, that you will have to have read it.
Which brings up a really important point. A lot of places have handbooks that haven't been read. And so that doesn't help us, right? So as an employer, as an HR person, as a manager, as a company, we put a lot of time and money and effort into this handbook. And so we want people to read it. And, we notoriously joke that no one ever reads it, but that's really a reflection on us. And so if your employees aren't reading your handbook, shame on you. One of the main reasons we have employees say, well, I never read it, was they think like it's too cumbersome, it's too difficult, it's too full of legalese, it's not employee friendly. Well, what good is an owner's manual if the person it's trying to help can't interpret it? It's kind of like IKEA instructions, right? Have you ever bought IKEA furniture and you're like, oh my gosh, how does anyone figure out how to put this stuff together? If we're not putting the instructions and the rules of the game at our workplace in plain English in a way that our employees can understand, and we're not incorporating it into our onboarding and orientation and our performance reviews and consistently helping them be familiar with the rules of our game, how can we expect them to be successful? So the goal is to write an employee handbook that is in plain English and that they'll read, and that you're going to encourage them to read in your new hire orientation. You're going to give them, maybe even give them 1 to 2 hours at their desk or in HR's conference room, paid to review the handbook, to jot down any questions, and to sign the acknowledgement form at the end. Maybe you're going to do a video recording of the key highlights. We want you to read the entire handbook, but we specifically want to reference a few policies that we want to bring especially to your attention. Let's talk about our harassment policy. Let's talk about our complaint procedure. Let's talk about what our dress code is. Maybe pick 5 of the most common things that you're like, we really want people to know this right from the start. So find a way to make your employee handbook a living and breathing, valuable resource to your employees. And then secondarily, you should be doing training every year with your managers on the employee handbook, because the managers are your frontline enforcers. If they don't understand the rules and the policies in the handbook, how can they be a resource to the employees who says, I don't know what I'm supposed to do when I have a death in my family. Do we have a funeral leave policy? You don't want everything going to HR or your office manager / accounts payable / HR person. You want the manager to say, you know what, let me check the handbook. That's my go-to. Whenever there's an employee question, my first resource is go check the handbook. Let me see if we have a funeral leave policy and I'll get back to you. So it needs to be employee friendly and manager friendly as well. So thank you for pointing out, Joanne. The most common problem is people don't read their handbooks. So that is on us as owners, managers, and HR professionals to craft a tool that is helpful in guiding our employees' behavior. If they're not reading it, it's a waste of time and money.
It's really true. I mean, and I feel like a lot of the time when we meet with a business owner and we're suggesting that they meet with someone like you to put something like that in place, it's almost like a fly at the picnic. Like they just want it to go away. And it's like, no, this actually, like, you shouldn't be in business if you aren't going to pay attention to these kind of things, because, I always joke, and possibly on every single webinar, Morgan & Morgan for the other people. Like they're, the old adage of like, you fire someone on Friday and they're open on Saturday. So they're going to call. And if you want to protect yourself, you've got to have these things in place and understand them and use them and it's really something that people put to the side, just like the operating agreement. Oh, it's no big deal. Like, it's a huge deal. It's just not a huge deal every day, like your car insurance. You don't crash every day, but when you crash, you're really going to need to have a decent policy. So
It's exactly the same. Yeah, I used exact same insurance analogy. These handbooks are not that fun to write, but you can hire someone to write them for you. So you don't have to keep up all night about this. But it is one of the greatest insurance policies, because when and if something does, you do get accused of something, or even if you just need to tamp down an issue real quickly, is to be able to say, hey, we have a policy about that. Let me remind you of the policy. Let me remind you of the rule. And so it just is such an great insurance policy, and it helps prevent a lot of situations from going further. And it certainly helps shut down allegations and some litigation and minimize risk. If we can get, if they have one and something arises and they have a plaintiff's attorney, one of the first things I like to be able to do is say, well, you know what, this is the first time we've ever heard of your employee, your client's harassment situation, and we have a harassment policy. They signed it. It has a complaint procedure. They signed that they received and understood all of it. And this is all news to me. I've never heard about any of this harassment complaint, and neither has my client, and they can't fix something they don't know about. Changes the whole conversation going forward when you're accused of something. So huge insurance policy by having an employee handbook. Some of the most, so just to touch on some of the most common mistakes that I see employers are, as you mentioned at the beginning, oh, I can find one of those handbooks on Google. So I have clients all the time say, oh, I can find a form handbook for $300. And I'm like, yeah. And that's about as worth as much as the paper that it's written on or the electronic document that you get, because I have seen some form handbooks that actually make my client in a worse position. So for example, probably the most extreme example was a client who had gotten their handbook, form handbook offline somewhere, or from one of these companies that will produce one quickly for you. You answer some questions, they build it into a template, spit it out. And in the handbook, the employee was wanting to claim FMLA leave. Well, FMLA, Family Medical Leave Act, only applies to certain employers of a certain size with a certain number of employees within a certain geographical mileage distance. So my client the law was not big enough for the law to apply to them. So great. So we don't have to offer FMLA. It's not required that we hold someone's job for 12 weeks. Until I opened their handbook and they had an FMLA policy promising employees FMLA that they didn't have to under the law. So when I said, why on earth did you voluntarily, like you're a small business, like less than 15 people, why are you offering to keep people's jobs for 12 weeks and doing all the things that FMLA requires? And they're like, well, we don't know. It was in the handbook we purchased. I'm like, well, who told you that law applied to you? And they said, no one told us, it was in the handbook package. Well, once we promise our employees this benefit, it's a little difficult to, when they go to take advantage of that leave, say, oh, sorry, that was just a mistake. We put it in our handbook, but we didn't mean it. So form handbooks can be a real problem. They may contain language that don't apply to you. They may contain promises that you can't keep. Oftentimes they're sufficiently generic that they touch on topics, but they don't really provide enough information to effectively manage the common staff questions. Sometimes they're inconsistent. Like I'll see one policy, but I'll go, well, later on your policy says this. Like there might be inconsistent policies in the handbook or inconsistent policies between what the company has issued before the handbook came out, and now the handbook says something differently, and they don't tell people that it supersedes. Sometimes they get really too specific. If you get in the weeds and have every play-by-play detail, that's a common error in handbooks. Like literally every play-by-play detail of a process ending up in the employee handbook is exactly what plaintiffs' attorneys want to go through step by step. They want to see whether you did every one of these, and anytime you stepped outside the lines, you might be discriminating against their client. So sometimes people put way too much process and procedure in their employee handbook. So commonly what I talk to businesses about is, an employee handbook is a set of guidelines of expected behaviors of the employee primarily, and it allows you to reserve some rights like at will and put some EEOC and some legal compliance language in there. Your play-by-play details of how we do those things go in an administrative policies and procedures manual or an HR policies and procedures manual. So when we have a policy that says, if you're going to take funeral leave, for example, we don't need to put in the employee handbook. If you've experienced the death of any one of these kind of close family members, and close family members are defined as blah, 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 you must fill out a request for funeral leave within 24 hours and turn it into the director of HR, and she'll confirm or he'll confirm that you can take off. We don't need all of that play-by-play detail in the policy. That would go in our process. Like, what do we do? Where's the form found on the intranet? Who do they turn it into the supervisor first and HR last? Do they do something on their timesheet? Like all of that goes into process and procedure. In the handbook, we would just say to assist our employees in dealing with the grief associated with the passing of a close family member, the company offers up to 3 days of paid funeral leave to its full-time employees. Close family members defined as, or immediate family members defined as the following. Please contact HR, or please submit the request for time off, or please contact your supervisor should you need to exercise this leave. That's really all the handbook policy needs to say. So if you get into all the play-by-play processes and procedures, it's just fodder for plaintiffs' attorneys, and many of those steps go in a process and procedure manual.
And those are things that might change, so you don't want to be changing your handbook all the time as well. And the other thing about change that I just want to jump on before you switch gears is oftentimes, at least in the corporate setup side, I see people buy those packages of documents and then worse, like they're bad enough, and then they get into make their customizations that they do themselves. And that is a good way to guarantee you've got some conflicting provisions, because you decided you want to add funeral leave and you didn't see it, but you don't realize that it's somewhere else, or they provision on page 9 says 3 days and now you say 2 days in the same document. Like, the worst thing you can do is make your own modifications to something you already didn't get advice on. Like, it's bad enough to buy the thing with no advice. Worse is to then customize it yourself.
It becomes a complete patchwork. So I always tell people, please don't call your brother-in-law and say, hey, does your company have a policy on pet leave, or pets at work, or bereavement leave? Or does your company have this? Or at Thanksgiving dinner saying to your sister or your mother-in-law, hey, does your company, or have you ever worked anywhere that has a dress code? Could I just use yours? Like, I see clients all the time to say, I borrowed, or I took a compilation of several other ones and I put them together. And I'm like, this is just, your handbook is not a patchwork quilt, right? Your handbook is designed to be personalized to your business. It needs to fit together. It needs to be comprehensive, and it needs to like make sense. And so the other analogy I try to give to people is, a handbook for me is very much a foundational item of getting your employee house in order. So your human resources side of the house, I usually talk about really 4 key tools you want to have. And I already mentioned them, that lawyers always ask for them. And so that's the job description, employee handbooks, employment agreements are another common one, and like job offers that lay out things. So laying out a foundational HR house, we wouldn't go to 3 different bricklayers and concrete people and multiple, and say, hey, can you do this wall and you do this wall? And hey, could we put a little bit of this in here and a little bit of that? And can I borrow my brother-in-law's this? We don't do a patchwork in our foundations of our home. So don't do a patchwork when you're building the rules of the game for your employees. Handbooks are just so important. And I know, I get it, they're super time consuming. And for most people, they don't really get excited about them, but it's worth the investment of time and money to have this. I can tell you, once you have it, it makes it so much better for your employees and your managers to just refer directly to it. It'll take so much headache off your plate going forward if you put the time and money in now to get a really well done, customized one that will serve you well in the future. And then you should probably look it over at least annually to see if it needs to update because of any current case law changes, or any legislation that's changed. So if you get a really good one, it should serve you well for a good long time, with an annual, just a review, just to see what's changed. Like, we've been changing them, several of them, because of making some amendments because of COVID. And I'll touch on some of the things to double check, but this is an exercise you have to do every year. Do a really solid deep dive, and you give a great handbook at the start. And then you can just do a kind of a review and refresh of a few pages or a few policies each year if needed. The last thing I'll just say is about making sure that your handbook is not out of date. I have plenty of clients that I'm like, when's the last time your handbook was updated? And they say like 20 something. If it's in the 20s, I had one that was 1986. And I'm like, that doesn't fly today. There's almost nothing in that handbook that's going to fly today. So in general, what I tell people is, you really need to have had a deep dive, either rewrite or review of your employee handbook, at least in the last 2 years, if you really want to be honest. But if you even have a 5-year-old one, we could probably review it and just give you updates. But a serious review needs to take place. We have a solid starting point and a really good handbook that's legally compliant now. And then each year you can just do a refresh of reviewing any legal changes, like social media and vaping. Like, we had to update a lot of them a few years back when e-cigarettes and vaping became really popular. They weren't included in the smoking policies. And so we didn't rewrite the whole handbook. Maybe we only updated policy number 27, and we issued it to our employees with a signature page. Hey, here's our fresh page 27 to include vaping. Or we never had before breastfeeding policy, but we know now that it's required for us. And so here it is, this is a new page. Please add this in as new policy 54. So you don't have to do a complete rewrite, but they do have to be reviewed, I would say, at least annually, to make sure you're still compliant with the existing laws and any changes that have happened. So those are my most common problems: form handbooks, too much detail, inconsistent with the other policies in the handbook, out of date. Those are the common ones, and not written in plain English and too legalistic would probably be the other thing I would just add to the list, is if it just doesn't help employees understand what the heck is going on. So let's jump into some of these topics then. You may already have, if you do have a handbook, you may have some just general, what I call the warm and fuzzy stuff at the beginning, like the employer's mission statement, vision statement. I'm trying to think what else I've seen at the beginning. If you have values, just any of those kinds of cultural elements that your business may have, you may have those at the beginning of the handbook, a welcome letter frequently. So generally the beginning of the handbook is kind of a warm and friendly, sets the tone for the handbook. If you're going to refer to employees as employees or team members or associates, and it just, usually there's a welcome letter from the CEO welcoming them to the team and talking a little bit about the value of the employees to the team, and some kind of opening, mission, vision, values, that kind of thing. What we also want to make sure that we have somewhere in the handbook. So just, these are some of the kind of key essential topics we want to make sure are covered. EEO statement, right? We want to make sure that we affirm our commitment to equal employment opportunity, meaning that we're not going to use any of the prohibited class information in our hiring, in our promotions, in our pay, in our performance reviews, those kinds of things. So making sure you have a developed EEO statement is super important. Making sure that you have an at-will employment statement. So, several states, including where you guys are, where I am, so Ohio and Florida, at-will states. So it's really important that we put in our handbooks that this handbook in no way alters the at-will employment. I mean, this is so important. I've even been with one attorney who puts it in the footer of every page that this is not a contract. Every page of the handbook has a footer. So in general, what we want to make sure is that we communicate this is still at-will employment, and putting these provisions in our handbook doesn't create a contract of employment with you. It's really just designed to provide guidance on expected behaviors and a little bit about our benefits and our culture here, but it in no way forms a contract. So super important that you have the at-will employment and the fact that this does not create some kind of contractual relationship. So make sure you have that in there. Generally, we have a purpose statement on what this handbook is designed to do, and then it supersedes all prior versions. So if you have in the past distributed handbooks, or maybe even just one-off policies, a lot of small businesses I have will say, well, I've never really put together a handbook, but 1 month we issued this policy, and then someone had a question about this, and so we issued a policy on that a couple weeks ago, and I guess maybe before I got here they had a policy on this, and they have this like whole collection of one-off policies. So we want to make sure when we do this handbook, we specifically say this supersedes all prior, written and verbal instructions or policies or procedures that have been communicated, policies, not procedures, communicated in the past. So we want people to know, hey, look, these are the ground rules. And so if you have something in writing from a previous supervisor, that's now null and void. So you want to make sure that you have these kind of core elements somewhere, usually toward the beginning of the handbook, letting everyone know the purpose of the handbook, the at-will, it's not a contract, and then any of the warm and fuzzy stuff that you want to tell about your company. So we want to make sure those are in there. And just so you know, right, I'm sure you've heard this all a million times, at-will employment, and I probably go over this at least once a week with a business owner or HR person, does mean that both the employee and the employer have the opportunity to discontinue employment for any time without notice, and for the employer, except for any they can't use any illegal reason, right? So we have the ability to terminate employees at any time without notice for any non-illegal reason. So oftentimes employers say, well, it's really been so eroded, we don't have at-will anymore. Well, you know what? That's a conversation for another day. In reality, we still are at-will states, and we want to preserve our at-will status as much as possible. And making sure that we have that in our handbook and we communicate that in our job offer letters and things like that are super important to reinforce that notion that we are still an at-will employer, and we've not given up that by creating any kind of contractual relationship. Now, if you do have employment contracts with people for periods of years, that's a little different. That's not at-will employment necessarily anymore once you have employment contracts for periods of time. So that's a different topic. Some things you also want to keep an eye out in your handbook when it comes to at-will. Courts have found that how you word some things in the handbook can give employees the impression that it's not at will. And so I don't know if you've ever seen these terms in your handbook back in the day when I first started in HR a long time ago. Probationary period. Well, that's a no-no these days. We don't want to refer to a probationary period. Somewhere along the way, the courts and governing agencies interpreted probationary periods to mean that once that was over, you were securing permanent employment. Well, permanent employment is not the same as at-will employment. And so probationary periods were triggering in people this expectation of something more than at-will employment. And so for years now, we've been advising clients to get rid of the notion of probationary period. Well, what do you do with it then? Well, maybe you recall it initiation period, orientation period, introductory period. Like I've seen businesses call it all kinds of something. But then I also say, do you even need it? Like what happens? So if you had a probationary period now called introductory period or whatever you want to call it, why? What happens? So it used to be back in the day, once you finished your probationary period, maybe it was 90 days, your sick and vacation turned on. Maybe your benefits like health insurance turned on. There was some triggering event that when you finished that 90 days, wow, all of something came available to you, maybe a pay raise, maybe benefits, paid time off. But I have plenty of clients today that because of the competitive HR world are starting benefits immediately, that they're not triggering that 90 days or whatever it is, isn't triggering something. So I really suggest that you look at, if you do have probationary period, one, you change the name of it, but two, you consider, do we even need it? If nothing is changing at the end of 90 days, some places will say, well, in that first 90 days, we can fire him for any reason. I'm like, that's any day.
Exactly.
You can do that on day 91, day 100. There's no magic. So at-will employers have the right to terminate at any time for any non-illegal reason. So we don't need a magic 90-day window to fire you. So reevaluate whether you even need a probationary period or not. And if you do, consider changing what you call it. Another problem that gets at-will employment tangled up is if you have progressive discipline. So I strongly caution you from having any policy that specifically says, if you do this, you get this discipline. If you do this, you get this discipline. If you do this 3 times, you get this discipline. Okay, because having all of that in there means you have, when you say you will or you must, then you're committing yourself to always doing it just like this. What we want to say is we have a discipline or corrective action. This is what the policy would say, corrective action program that includes written warnings, verbal warnings, suspensions with or without pay, up to and including termination, chosen by the company at its discretion, depending on the severity of the infraction, period. You as the employer want to have the right to choose the appropriate corrective action that is consistent with the level of whatever the violation. So the discipline needs to fit the crime. And how many times they've been doing it. So don't lock yourself into, if this happens, we will do this. If you do this 3 times, we'll do this. I find that it's much better to have a policy that says we have all of these tools in our corrective action toolbox, and we're going to pick the one that's appropriate for the situation at our discretion. So you can really lose some of your at-will freedoms by having a really tight progressive discipline policy. So that's a second way that you can lose your at-will, is with the probationary period, the progressive discipline, and then creating messaging that lets employees think that you don't fire them without good cause. Like we don't go around putting that language in at-will employment materials that will only fire you for good cause. You want to make sure you have the discretion to let people go for any non-illegal reason. And if you use job security statements, that creates a false impression for the employees, and it may lose your at-will employment status. So you don't want to have things like that written in your handbook. Wow. Another critical point in your handbook, overtime. So I don't know how many of you have non-exempt employees. So non-exempt employees are entitled to overtime for any hours over 40 that they work in a pay period. And it's important that, one, you have a policy that tells what the pay period is, because if you don't have one, then the Department of Labor will determine what your pay period is for you if you get a wage and hour complaint. It's important that you tell people that they're not permitted to work off the clock without permission, but that if they do feel they need to work off the clock, that they should let a supervisor know. But one of the most common things I see companies do here is say, well, they didn't get permission, so we're not paying them. Not allowed. The law says if they work it, you have to pay them for it. So even if they didn't get permission and they worked more than 40 and they're overtime eligible, you have to pay it. But what you can do is, if your handbook policy says you have to get prior approval and they didn't get the approval, you can discipline them under your handbook policy, but you can't withhold pay. So it's really important. That overtime policy is probably one of the most important ones that I find with companies, that if we can get it crafted it's important to get it crafted legally compliant, but it really helps them manage their staff. But
Mhm.
keep in mind, the policy needs to say, if you want to have prior approval, but we will pay you for all hours worked. It's because we will always commit to paying them for all hours worked. And we will not ask you to work off the clock. And if you're asked to work off the clock, to please report it to HR immediately. So there was a point in time where companies were doing lots of shady stuff with overtime. And so we want to make sure that we let people know that, hey, we think you can get this job done in 40 hours. If you can't get it done in 40 hours, please talk to your supervisor and get approval. We will pay you for any hours. You'll pay your overtime rate over 40. And if you're asked to work off the clock, that's prohibited, and talk to us if someone asks you to do that. So that's our commitment to following the wage and hour laws. And by putting that in there, it's a good way for us to reinforce that this was what we wanted to do. This is what we're going to do every time. And when a plaintiff's lawyer says, hey, you've been screwing my client out of overtime for years, at least we can say, well, they never brought it up. I mean, it's not going to always win it for you automatically, but we can say, well, we didn't know that. You better hope you don't have cameras showing them coming and going, or a boss putting in texts or emails saying, hey, I need you to stay late right now. But we want to be able to say, we have a policy that says, please get it approved in advance. We never heard from them. We would pay them if we knew they worked it for sure. And we have a policy prohibiting off the clock. So we're doing the best we can to try to avoid screwing people out of overtime. So as an employer, I jokingly say, a lot of these employment laws can be really frustrating for us. And we're like, well, isn't this common sense? Well, for every one of these laws, there were a bunch of employers that were just bad actors. Mm-hmm. And the federal government had to step in and make businesses behave because they couldn't behave themselves. So when you're like, this should be common sense, you're like, yeah, you're right. It should be common sense, but employers weren't doing it. Mm-hmm. So the federal government stepped in, and if we're going to be a good employer, we're going to commit to this in writing, and we're actually going to do it every time. Wage and hour violations are a huge problem for employers, so having this policy is really important. Yeah. Harassment and bullying policies, another kind of legal compliance topic to make sure you have in there. So you want to make sure you have a really clearly worded harassment policy, and you should have it include bullying as well. We're seeing a lot of bullying taking place. Have definitions of what those behaviors involve, have examples. What's considered to be inappropriate harassment at work, what's considered to be bullying at work, and have not only policies related to sexual harassment, but now we know you can be harassed because of other things as well. And so make sure your policy on harassment touch on a variety of different kinds of harassing behavior, and make clear to employees what's not okay. So descriptions of the behaviors are important. You should have a complaint process. So who should they notify if they are experiencing or if they observe it, right? Bystanders should have an obligation to let someone know. So it's not good enough to say, well, it didn't happen to me, but you were standing right there in the employee break room when he went around snapping bras, or when she went around making this comment. So if you see it as an employee, you should also have an obligation to let HR know. So if you experience it, if you see it, or if you become aware of it. So we want to make this responsibility on employees to let us know if they become aware of these things happening from any of these situations. So if they experience it, they observe it, or at the bowling league on Wednesday night, a coworker says, you're never going to believe what he said or what she did. So we want employees to come back and say, hey, this is happening at work. And we as an employer want to take it seriously and do what we can to minimize this in our workplace. If you don't create an avenue for employees to tell you about this stuff, they will then find an avenue on social media to tell the whole world what's going on, or they'll find an attorney, or they'll take it to the EEOC. So it's in your best interest to have really clearly defined expected behaviors or prohibited behaviors, and a really clear complaint process on how to bring it to the company's attention if people are experiencing it. So make sure that's in your handbook somewhere. And just as an aside, you should also make sure there's plenty of training for your employees and your supervisors when it comes to sexual harassment policy, and also your bullying practices as well. So we want to have our policy, we want to have our complaint procedure, and we want to have training in place for our employees on what that policy is. Another section in your handbook, code of conduct, super important. So requiring employees to be respectful, refrain from arguing, things like that you might see in a code of conduct policy, how we want them to behave at work. What they can and cannot say, though, needs to be very carefully crafted. And this is where attorneys come in handy again, because there's some things that you cannot put into your code of conduct based on the National Labor Relations Act. So the NLRA Historically, people thought that only applied to union environments, but it applies to union and non-union. And so there's some protected speech in the NLRA that applies to your workers. And so we have to be very careful about what we say they can and cannot say at work, but we can expect them to be civil and respectful while they are at work. But just be careful about how you word that respect and civility policy. They've had a lot of legal, a lot of cases filed around what's in civility policies. And so we have a lot of guidance out there about what you can and cannot put in a civility and code of conduct policy. Another hot topic is workplace recordings, right? Every employee has their cell phone and with them, and who knows when it's running. And so it's really important that if you don't want photography and videography and recordings taking place in your workplace, that you have a policy about that. And if you are specifically in a medical environment, you need to be absolutely certain that you have a policy about what your workers can and cannot do with regard to patients and privacy of information and their images and things like that. And so really think long and hard about what you want to have in a photography, videography, electronic devices policy. Many employers don't want pictures taken for trade secret purposes. Maybe they have special formula or equipment or I don't know, something that they just don't want the whole world to see. And so they prohibit any kind of photography and videography of company processes or trade secrets. Again, I'll caution you that employees do have some rights if they're recording something about their terms and conditions of employment under the NLRA. So if they're recording unsafe working conditions. So for example, if something is creating a hazard or is creating an unsafe environment for them, they can take pictures of that. They can record that. If there's something that's affecting their terms and conditions of employment and they need to capture it. So our policy would make sure that we're not infringing on that right, but we do have the right to control what else is photographed or videoed or recorded in our workplace. And I jokingly tell every employer I work with, you should presume you're being recorded all the time. Anytime you're going to talk to an employee, just behave yourself like you're being recorded. And would you want what you said or did posted on the giant billboard downtown or spread across social media? So just presume you're always being recorded in what you're saying and doing, specifically if you're talking one-on-one with employees. You should have a policy or think about your policy on personal electronic devices. Are they allowed to bring their personal electronic devices, their cell phones and their smartphones and laptops to work? Are they allowed to use them for work-related business? Is the company allowed to remotely wipe them when the worker leaves? So they have a lot of company data on their devices. What's going to happen to that data when they leave? So this has become a huge issue during COVID because phones are bouncing out to personal cells, workplace phones, and might be getting the person's individual voicemail, might be sending emails to the person's phone, might be putting them in the person's contacts on their personal cell phone. And then when that person leaves, before we wouldn't let you take our client list, but now it's on your cell phone. And we wouldn't let you do this or that, but now it's all on their cell phone. And so make sure that you have given serious thought to your personal electronic device policy and work with your IT provider on protections, such as being able to do a remote wipe, which allows your IT company remotely to wipe stuff off of their personal device with their permission as part of your policy, if you need to. So it's really important to talk about that policy and confidentiality and how you're going to protect your own information. You should think about policies on texting and driving. Do your employees have, are they taking phone calls or texting while they're out on the road for business purposes? Do you want them to pull over? I mean, I made a few notice of major lawsuits where an employee driving a company car makes a personal call. So driving a company car makes a personal call and rear ends another car, $21.6 million lawsuit. Employee talking hands-free on a business call, according to company policy. So they were allowed to take business calls. So they're following the policy, strikes another vehicle, $21 million outcome in that suit. Tractor trailer driver checks his text messages and crashes into stop traffic, 24.7 million. Employee who was lost and using GPS on his phone read a red light and crashed, 4.1 million.
Wow.
And a salesperson making cold calls on his personal cell while driving his own car. So cold calls on his personal phone, driving his own car to a non-work related event on a Saturday night, $500,000 settlement. So texting and driving is a big one. And I'm looking at our time here just to be mindful of that. I want to just run through a couple of other topics to make sure you think about religious accommodations in your handbook. Think about confidentiality and conflict of interest policies. And I'll also just note here, if you have confidentiality, conflict of interest, non-compete language in your employee handbook, that's fine. But that handbook expires when that employee quits. And so I had a company just this week who is having a situation where someone left and they've gone to a competitor, and they have been reaching out to vendors and possibly even clients of the previous employer. And they have a handbook policy that prohibits it, but the handbook policy is null and void when you're no longer an employee, and we can't punish you or discipline you when you're not an employee. So the handbook does not outlive the employment relationship. So how do we do that? We have to have separate agreement. So a non-disclosure, a confidentiality, a non-compete, a non-solicitation, a non-disparagement needs to be in a separate standalone agreement that they sign as a binding contract that follows them after work. So it's fine to have it in your employee handbook, but know that it doesn't provide any restrictions on their behavior once they're no longer an employee. Employee handbook only applies while you're an employee. So if you want those kind of restrictions, they need to go in a separate agreement that's signed by the individual also. You might want to think about a weapons at work policy. We've had some changes in legislation on concealed carry and where concealed carry folks can bring their firearms onto our property. So make sure you have thought about what you want to do about weapons at work. If you put benefits information in your handbook, this is one of those areas where less is better, because as Joanne said before, you don't want to change your handbook all the time, and benefits tend to change on a maybe even on an annual basis. So don't put in there, we're going to put $250 toward everybody's single medical premium. Just say that the company provides, family medical or medical insurance program. Details are available from human resources. Don't get into all the details and pricing and percentages, because if something is going to change on an annual basis, you're going to be changing that employee handbook policy every year, and you don't want to get into that. Think about making sure that any kind of policy against gender discrimination and all the discriminations has been updated for transgender status, sexual orientation, that type of thing. Make sure that if you do have a bereavement or funeral leave, that you've updated it for languages that don't say husband and wife anymore. It should say spouses or legally recognized partner. So just make sure your policies don't have language that's no longer acceptable. So spouse is one of those things you want to watch for. Think about your marijuana and drugs at work policy. A lot of things have changed with regard to drugs at work. You might think about if you need a handbook policy on car insurance. If you have people driving for work, you likely have business insurance, hopefully, that's covering them if they're driving for work. But oftentimes your insurance company requires that your employees carry minimum insurance requirements of their own. And we would oftentimes mention in our handbook if they have some minimum requirements. We may not mention the dollar amounts in there, again, if it might change, but we may say they're required. You might also think about an amorous relationship, or we call this dating our coworkers policy. We'd like to not have to get into these topics at work, but this can really throw a wrench, particularly when relationships go sour. If it's a supervisor, they may accuse us of discrimination or being passed over for something. And so we're seeing an increase in amorous relationship policies. The other one we're seeing an increase in is pets at work and tuition reimbursement policies. Those are probably the two most common ones outside of COVID policies that have been asked to write in the last year. Are pets at work? When are we going to permit them? Are we only going to permit them as an accommodation? Make sure you know the difference between therapy pet, comfort pet, emotional support pet. They're not all the same, and you're not required to accommodate all of them. So pets at work has become a popular policy, and so has tuition reimbursement for people going back to school and helping your employees get their education. Just a quick reminder then, I jokingly say the section on the that was then, this is now, some things that maybe your old handbook still has. So these would be some red flag terms to look for in your old handbook. If you are referring to the probationary period, that's definitely one you want to get rid of, the term. If you have anything in your dress and appearance policy that says women shall dress like this, like my favorite one when I was first working was that women shall wear hosiery, there should be no bare legs. Yeah, that doesn't fly anymore. Or that women could wear blouses and skirts, but men could wear khakis and blazers. And so any dress code that specifically references gender requirements should be carefully reevaluated, because those don't fly anymore. And so what we typically are going to say is appropriate dress would be business casual, which means this, or I find it's more helpful to say, which means not this. If it's appropriate for the gym, the beach, a nightclub, that's not appropriate at work. So get rid of gender references in your dress code and appearance policy, and just think about a standard level of expected attire regardless of gender. Also be mindful of the Crown Act, which has not been adopted in Florida or Ohio yet, but it has provisions that prohibit you from discriminating based on ethnic hair. And so we're very careful and mindful of making sure that we don't have policies that prohibit braids and that they're only applied to African-American employees. So review your policies, particularly when it comes to dress and appearance and hair, to make sure that you don't have anything in there that is specifically going to be targeted toward genders or specific races. Get rid of any policy that says you're prohibited from talking about your salary. That doesn't fly anymore either under the National Labor Relations Act. When I first started in HR, that was in everything. You couldn't talk about your salary. When we gave you a pay raise on our form, it said you're prohibited from discussing your salary with other employees. That doesn't fly anymore. So if you have a handbook policy that says you can't talk about your salary, you need to get rid of it. That's a term and condition of employment. And if employees can't talk about their salaries, how do your discriminatory pay practices and the fact that you pay women $20,000 less ever come to light? And so they don't, you're no longer permitted. If it was ever actually permitted, I don't know, but it definitely doesn't fly today. So none of that language. And then if you have language that says you have to exhaust all paid leave before you can take unpaid leave, you may want to have your attorney look at that for accommodations purposes. So, and just to recap, things that I suggest you don't include in your handbook are play-by-play details on your benefits plan. You don't need new hire information in your handbook. I find clients have stuff about the I-9 in their new employee handbook. That's a pre-employment, that's becoming an employee. We don't really need that necessarily, all the details of what you have to do on the first day and third day in our handbook. We don't need administrative policies and operational policies in there. Again, one size fits all policies don't work for every employer. Be sure you don't have arbitration language in your handbook. I've seen that sometimes, and that's a problem. And then laws that don't apply to your company. Lastly, I'll just touch on a couple of quick COVID policies you might think about. We've seen an increase in companies who did not have telework or telecommuting or remote work policies. And so we've been drafting them either as a temporary policy or now adopting them as a permanent policy. And why it's important to have that policy is we talk about there are several circumstances in which telework may be considered. A job may automatically be deemed remote work by the employer. It may be upon request by the employee or by the supervisor, or it may be as an accommodation. And here are the factors we're going to consider. So remote work policies are really important, temporarily for sure, but also considering that it may be the new normal for your workforce, or it may not. You might be in an industry you can't do telework, but it's still important to have a policy that says these are the factors we consider, because 90% of your workers might not be able to telework, but maybe accounts payable can, or maybe the executive assistant can, but all the rest of the workers can. So we want to have a practice for how we reevaluate positions for remote work eligibility. So that's the most common COVID kind of related policy. If you're doing any of the COVID paid leaves, we're adopting temporary policies for that. Safety, workplace safety policies. We've been modifying some of those with whatever was going on with the masks and workplace safety issues. And travel, the difference between essential and non-essential travel, and when employees were going to be required to participate in workplace travel again, or perhaps be given the option not to do workplace travel. So depending on your type of work that you do, one or all of those kind of COVID policies, they don't have to be COVID specific, but they've all kind of come on the radar now because COVID has put all those topics in the forefront. So it's helpful to have a policy that you can tell employees, hey, this is how we do that, and be able to hand them the telework policy or hand them the safety, the mask policy that you're going to implement. Lastly, then I'll just conclude on some of the things that the most common questions I get about handbooks is, so we have a new handbook, how do we launch it? I highly recommend giving everyone a hard copy whenever you do a big rewrite or have a fresh new handbook, and giving every new hire a hard copy. Well, why is that? Yeah, I know it's expensive. Yes, I know it's a pain in the neck. Yes, I know it kills trees. But what did I tell you at the beginning? We want them to read it. How many people are going to read hard copy versus electronic copy? Many more are more likely to read it in hard copy, and specifically if you give them time to read it. So I recommend giving them a binder, a bound copy, something hard copy at the beginning, time to read it. And then they need to have an acknowledgement and receipt page that says, I've read it, I agree to follow these terms, I understand it's not at will employment. And you want to have a signed copy of acknowledgement and receipt for every employee. So I highly recommend hard copy. Electronic is also permitted, but you still got to collect back a receipt somehow electronically in confirmation. So you want to have you want to have something readily available to the employee. You want to have a receipt page available to the employee. And then you want to keep all past versions, because when and if an employee brings a complaint, sometimes you've revised your handbook recently, but they're making a complaint about something that happened at the end of last year when you had a different handbook. And so don't just save over your old one every time. It's important that you keep a final version in electronic format of every year's handbook, so that when and if some kind of complaint or litigation comes up, you can give me the handbook from 2019 or 2020, not just the current one. So making sure that you keep the electronic, keeping a version around, hard copy or electronic, and making sure everybody reads it, and making sure you get a receipt page. And just as an added kind of tip, I recommend on that receipt page, if you can, to the extent you still have hard copy personnel files, make that acknowledgement page on a different color paper. Like, I'm a big fan of goldenrod. It's like the only thing I ever use colored paper for, but I tell my clients, get that signature and receipt page and print it on goldenrod and have them sign it, because when and if you ever need me to do something, the first thing I say is, have they signed your handbook? And if you can open that personnel file and amidst all the paper you see goldenrod, that's what you're going for. So that's a really gold mine piece of information to have that signed handbook page. So I recommend putting it on prominent colored paper. I think that's kind of a lot of high level stuff and some details in a nutshell. I see we have like 2 minutes left, Joanne. So do you have
I just want to say thank you. And if you still are interested in running a business after this, that's the biggest thing people come back to me for, is like, it's really like, it does, when you do it all at once, if you're going to do that overhaul, if you do have the 1993 handbook that's not been touched, it is going to be tempting to feel like, is it really worth it? Like, maybe it'll just be me again. But it is painful. It's almost like estate planning. And once you get it done, then you're in the clear. You don't need to do the overhaul again for quite a bit of time, particularly if you can stay up on it. So don't give up. It's so important. And it is overwhelming, and it is frustrating, and it is costly, and it is way more expensive to be caught without these provisions in place. And we, of course, we are jaded because all we see are how things go wrong. So, people are just like, well, does that really happen? Yes. But a lot of times I hear back from people, whether it's operating agreement or employee handbook, they're like, I've been in business 20 years. I've never had a problem. I was like, that just means you're a ticking time bomb. You've been 20 years with no problem. Like, you're
and times have
likely,
changed.
Yeah. And it's changing.
If there's anything that I tell people, like that harassment policy, for example, there's a lot different behavior today that don't fly. Just like Governor Cuomo said, the bar changed, the bar moved on what was acceptable. I don't know that the bar really moved as much as what he was doing, but it's important in your handbook to say these kind of it's important in your handbook to say, we don't tolerate these behaviors at our workplace, and use some really clear examples. Like, we don't hang nooses, we don't wear these kind of clothing, we don't put up, perhaps you don't do Confederate flags, whatever it is, put it in there for things that we tell people, like, this is not what we do here. What you do after 5 o'clock, that's a whole different conversation. But while you're here, we're not going to display and say and do things that create a hostile work environment for people. And this is what that looks like. Give them the tools to be successful, so they don't cross the line. I think a lot of people don't know any different. And my clients will say, well, isn't this common sense? And you're like, there's nothing common. We weren't raised by the same parents. Yeah. We didn't go to the same schools or the same religious upbringing. Like, there's nothing common. So if you want people to have a common set of behaviors, you have to tell them what those are in your work environment. Yeah. They don't know.
And it is your responsibility. So you can't just go, well, they should know better, or they don't fit the culture then, so they just won't work here. Well, that's a great way to have a wrongful termination suit. You can do that. That's not at will at its finest. So I will say, just to give you a little bit of feedback, we have one person who said, I don't have a question. I just want to say, after 25 years as a Macy's HR manager, Mindi hit on so many issues that come up on a daily basis. I love this presentation. Thank you. So great. You're always fantastic. We love having you. You, like me, are always stuck with not the most fun topics. So I appreciate your sense of humor and your willingness to shed light on these things. It's been a pleasure, particularly the COVID updates, because that stuff, it's hard. It's hard to accommodate and make sure that you're not changing the rule, and it's tough. So if for anybody who wants to reach Mindi, her contact details are available on our website, and this recording, as always, will be distributed on our YouTube channel, on our Facebook page, and on our Koontz Associates and Koontz Parkin website. If you have questions for us or other topics you'd like to hear about, please let us know. You can also join us next week. If you're still awake, you can come back next week and you're going to hear from me about seller representation if in a real estate transaction. So if you're selling your property and the buyer has the closing agent or a lawyer, a lot of times people ask me, do I need a lawyer? Don't ask a lawyer if they need a lawyer. If you don't want to hear yes, you need a lawyer. But if you want to hear yes, you need a lawyer, you can tune in next Tuesday and find out why.
And I think I'll be back with you in a couple of weeks. We're going to be talking about, I think, HR legal update sometime in the next few weeks. So you'll see me again if you had a good time today.
Exactly. What I'd love to see is you in my office. So get yourself down here.
I'll be there.
All righty. Thanks, everyone. Have a great week. Bye.